One of these days, the U.S. Supreme Court will tell us whether bankruptcy cases have a general exemption from the rule that arbitration agreements are rigorously enforced in federal court. But until that happens, on Rochelle's Daily Wire Video Edition, we will report individual cases as they come down. And we had a rather interesting case come down in the last week from Tampa, Florida. It dealt with whether or not an alleged contempt of the discharge injunction is subject to an arbitration agreement. Here's what happened. The creditor had a $500 claim that was clearly discharged in the Chapter 7 bankruptcy. But for some reason, a few months after bankruptcy, the creditor demanded payment of the debt. The debtor did just exactly what you suspect a debtor would do and dragged the creditor into bankruptcy court alleging contempt of the discharge injunction. But then the creditor raised an arbitration agreement in the contract with that creditor, which broadly required arbitration of all disputes. Well, bankruptcy judge Roberta Colton in Tampa, Florida, held that there was not going to be an arbitration, and she was upheld by District Judge Stephen Merriday in Tampa. And here is how the analysis went. First, the judges said that the contempt claim was not any dispute about the debt, because the debt was valid, it was allowed, but it was discharged. The dispute had to do with violation of the discharge injunction. It had nothing to do with the customer agreement or the underlying debt. And so therefore, it was not covered by the arbitration agreement. Second, the judges said that a contempt proceeding is an action by the court, not by the creditor, not by the debtor, but by the court, because courts have the power and the right to enforce their own injunctions. And because the court was not a party to the arbitration agreement, there was no necessity for arbitration of the allegations of contempt of the discharge injunction. Now, by the way, this decision doesn't tell us whether or not the creditor would be held in contempt. In fact, it only ruled that there would be no arbitration. Well, that's what we have this week on Rochelle's Daily Wire Video Edition. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will be back same time next week with something else that's happened of interest in the bankruptcy world.